Cause money doesn't equal happiness, do not confuse her. And life is ruthless, get to walking if the shoe fits. Cause everybody's got a memory lane, but as you're walking down it, all you can remember is pain. The moments that afterwards life was never the same. It's almost like something in your body chemically changed. Now you think the world's against you, I get you. Trust me, I have been through times I thought I'd never see an end to. When they said I couldn't, I just showed them what I can do. Ended up acquiring these gems that I lent you. It's now my duty to assemble a crowd, gather up positive energy, spread it around. And as the vibrations join, they develop a sound. It's profound. And I feel so free, yeah, yeah, yeah. And I feel so
Welcome in, welcome in, welcome in, everyone. Unbelievable news from the interwebs. Absolutely. All right, let me get all this stuff in front of me, and let me say welcome in to everybody. Hello, good morning, JC, John Eagle, Lou, what up? Gregory, what's going on? Big Bad Wolf, what up? Simba, what's happening? Evelyn, what is going on? Richard. Hopefully the audio wasn't trash before also, but maybe it was. Let me know if audio is garbage as we're going along here this morning, because we need we need to just tap in here. Tap in, and we got 24 pages of goodness. So we're just going to start at the top. This is last night, Illuminate the Dark posted this, and she posted a video going through the whole motion. That sucks that the audio for the music wasn't good. That'll be enough to turn anybody off, I guess. Sorry about that. All right, so you can go to Illuminate the Dark in the posts if you guys want to follow along. She's got a link in her Google Drive, and then she had a video that went over the whole thing. And then Liberty Troll posted one last night. So I imagine this is filed. I don't know how else these people would have gotten it absent that. So we're going to go over this because he's back, right? And I don't think it'd be good for us to not cover this, right? I mean, it's bad enough the stifling that they've done out there, but pardon me. We're just going to get right into it. All right, so this is a motion to modify conditions of probation. Introduction. Myers was sentenced to probation for 3 years on July 1st, 2025 in Pima County Superior Court. Judge Metcalf issued his order for special conditions of probation. And I'm just going to take a little pause here. Simba, that might have been from the Booing lawsuit, the Booing case. He just filed that lawsuit. So I'm not going to say that you're not one of the people paying attention, because I know that you are. But for people new here or new to the story, this is a very complicated story of corruption. And it might seem at times like I'm jumping, or the story's jumping all over the place, but that's only because of how absolutely insane this whole entire thing is. So in the second sentence, Mr. Myers references the judge that sentenced him, Judge Metcalf. I'm not sure if everybody is noticing this right here, but that's the Dabbler. And for people that don't know who the Dabbler is, we're going to do a whole... No, you're good, bro. I'm not even saying that you're wrong. Well, I am saying that you're wrong. I'm just... you get what I'm saying. I'm just saying that it's a long, convoluted story, and it's difficult to keep track of all of it if you're not tapped in. So I'm gonna try to tap everybody in who's not tapped in, and for everybody that is tapped in, I appreciate you being a shareholder. In the nonviolent army. So we're going to revisit the whole Dabbler, so the Dabbler was the judge that that oversaw the injunction hearing for Shannon Walker. Griffin is the one that kicked him out of the courtroom. He did allow him to stay if he would take a moment to regain his composure. He opted not to regain his composure and to leave the courtroom, and that's when he gave his ruling and waxed poetic about how he wishes he could help more and how he dabbles in the Constitution. So this is quite the turn of events to go from a Constitution-loathing judge, Judge Metcalf, who just thumbed his nose straight up at the law. It's now to the Dabbler, who dabbles, And I know that in the moment he made the wrong ruling, right? In the moment he didn't follow the law, but you know what? It's not even about giving the benefit of the doubt. It's about, okay, that thing happened, and now we're moving on. We're still talking about the law, right? We still have to base these things off the law. I mean, in theory, right? The law. It's crazy that all we talk about is following the law, and all of these oath violating government parasites, all they do is violate the law that they swore to uphold. So what this is, Chris, is this is a motion to modify conditions of probation. We're back. We're back with Lane. I know how much you've missed my streams on Lane, but Lane's right. He was always right. He's always been right, and you're fucking wrong. So, how about them apples? All right, so let's get back into this. And what the hope is we're hopefully this is forcing the dabbler to dabble, and we're some pretty poignant points are brought up here. We'll just we'll have to see how much dabbling he's done since the injunction hearing. Hopefully he's done some. Okay, so that included conditions listed in Exhibit 1. Myers has been on probation ever since following those conditions as they are being applied by the probation department. Myers wants to make clear that this motion does not arise out of a conflict with the probation department. The probation department has been nothing but professional, respectful, and very communicative. Whether Myers agrees with the conditions or not, he is aware that the probation department is not the one responsible for ordering the conditions. This is not about looking back at what has taken place since sentencing. This is about setting up a clear framework moving forward that is clearly defined for Myers, this court, and the probation department. Myers has taken his time to research what conditions the court may impose while following the required legal precedents. Myers now moves forward with this motion to clarify conditions of probation so his conditions can be modified in accordance with the court's duty in protecting the alleged victim while maintaining his legal rights free from threat of prosecution. Prosecution from the Pima County Attorney's Office, prosecution from the Tucson City Courts, Matt Walker, the alleged victim's spouse, who colluded and cooperated and shared work product with Rachel the retard over at the Pima County Attorney's Office. So yeah, I guess man, corruption really bothers me. I'll tell you what. So Myers moves this court pursuant to Arizona Rules of Criminal Procedure 27.3b to modify his special conditions of probation put in place July 1st, 2025 by Judge Metcalf. As instructed in the language of Arizona Rules of Criminal Procedure 27.3b1, any modification of probation must comply with case law and statutes, due process, and statutory limitations. Myers believes that the current conditions are not supported by existing case law and statutes, deprive him of due process, and exceed the statutory limits as they are currently written and enforced. Specifically, Myers argues that the following conditions are unlawful as currently written and enforced. Do not engage in activities that would reasonably expected to cause others to harass or contact the victim or her family. I mean, we'll have to parse all this, right? Did Mr. Myers ever engage in activities that would reasonably expect to cause others to harass or contact the victim or her family? What do you guys think? Has he ever done that? So, no. No is the answer to that question. He's never done that. In fact, he has encouraged others to not reach out in contact and to specifically not harass. Okay, so I know that we're just kind of rehashing, but it's so difficult not to, because it's these people that should be in a cage. Remove all videos from YouTube and social media that mention the victims or her family, including identifying information about them. Okay. This is going to be a major point of contention, because the Dabbler himself said the videos could stay. So, what are we doing here? What on earth could the Dabbler's argument possibly be? What was protected by the Constitution during the injunction hearing that he oversaw, he said, well, I can't do anything about those videos. The videos stay because it encroaches on the First Amendment. We're talking about the First Amendment here. The First Amendment's pretty important, right? I mean, we're at least pretending the First Amendment's important, right? Do not post information about the victim or her husband and 2 kids on YouTube or social media. Okay, do not post information about the victim or her husband and 2 kids. I don't think that's ever happened. A post information about. I mean, we have to be precise with our words, right? Post information about. I don't believe that's ever happened. Simba, you're exactly right. He advocated for the exact opposite. He said, do not. He said it when he was out of jail. He said it when he was on jail phone calls. Do not reach out to this person. Do not. So, okay. And here's the last one. Do not associate with or communicate with, directly or indirectly, Josh Gray or Mark Kelly. There's no reason. There's no reason. These 2 people, who knows why, they should not be able to associate with Mr. Myers. Do not associate with or communicate with, directly or indirectly, Josh Gray or Mark Kelly. Josh Gray and Mark Kelly, they must be 2 of the, I mean, they're probably on wanted posters in Pima County. I mean, they have to be, right? How can they not be? Stop that. Hey, stop. How could they, I'm pretty sure Mark lives out in Pima County. The fact that he's not in the gulag right now, I mean, this counts as evidence in Pima courts. So, I've probably got wanted posters, and Mark's probably in the gulag, so I don't know. This case goes to the core of the First Amendment. The sentencing court imposed restrictions impacting Myers' ability to publish statements concerning the professional history and performance of public officials. These statements are classic political speech subject to the highest level of First Amendment protection. Myers acknowledges that a probationer is subject to restriction of his constitutional rights to a greater degree than would be permissible outside the criminal justice system. State v. Montgomery, that stuff. noting that probationers enjoy a reduced expectation of privacy and upholding a probation condition which dictated that the defendant would submit to a warrantless search by police at any time. Exactly. I thought we had freedom of assembly also. And freedom of press, and the freedom of speech, and the right to petition. I mean, I guess this is the right to petition, but you have the right to petition others, right? You've got the right to speak to get others to petition. So, it's gross. And I don't think Lane Myers is the one that you're going to get this over on. It's just me. That's just me. They see, the thing is, here, hold on for a second. See, the thing is that they think they won, right? They think that on July 1st of 2025 that they won. They don't realize that shareholders play the long game, and that we can put up with tremendous amounts of pain, tremendous amounts of undue, I'm not sure what the word I'm searching for is, but the point is, shareholders stand on business. And the state, they don't have a leg to stand on. So while we stand on business and the law, they stand on gaslight and bullshit. And we're going to see. Because the Dabbler is going to be forced to dabble. He's going to be forced to dabble in this case. Dabble in the First Amendment and the Constitution. Unless, like Angie, the second he sees the motion, he says, whoa, I got to get out of here. I can't touch this. I can't touch Lane Myers. Myers argues there is not a reasonable nexus between these The question is whether there is a reasonable nexus between the conditions imposed and the goals to be achieved by the term of probation, State v. Davis. Finding such a nexus existed in upholding a condition prohibiting probationer from obtaining custody of her children. Myers argues there is not a reasonable nexus between these conditions as written and the goals to be achieved by probation. These conditions are both vague and overbroad and are not supported by case law. Myers argues these conditions can be modified to find that balancing point and still achieve the desired goals of probation. Distributing public information to third parties is constitutionally protected. Snyder v. State. The distributor of such information may not be held liable. Social media is protected under the First Amendment. Packingham v. North Carolina. Prosecution of speech that inspires others to take lawful action is unconstitutional. See org for a better Austin versus Keith. The claim that expressions are intended to cause a coercive impact on respondents does not remove them from the reach of the First Amendment. These special probation conditions imposed by the sentencing court do not engage in activities that would reasonably expect to cause others to harass or contact the victim or family, remove all videos from YouTube and social media that mention victims or her family, including identifying information about them, do not post information about the victim or her husband and 2 kids on YouTube or social media, are unconstitutional because they threaten political and other speech of public concern for no legitimate reason related to deterrence and rehabilitation, not least because they are excessively vague. All of these original conditions are void on their face because they unconstitutionally discriminate based on viewpoint, which the government may not do even when it may restrict content of speech. The court cannot avoid these constitutional requirements simply by labeling this as harassment and concocting its own blend of harassment elements. The strict requirements that protect criticism of public officials apply to any case, regardless of the legal theory used to punish speech. Apart from these constitutional questions, to import the complexity of constitutional law into a revocation and resentencing proceeding would undermine judicial economy and effective supervision by requiring an in-depth, factual, and legal analysis of context-dependent considerations. The sentencing court abused its discretion by imposing additional overbroad conditions on Myers, such as a blanket prohibition against posting public information about Matt Walker, not allowing Myers to associate with Josh Gray or Mark Kelly, not allowing Myers to speak about his own case, not allow Myers to criticize public employees because they are married to Shannon Walker, not allow Myers to mention or speak about Shannon Walker under any circumstances, which far exceed the legitimate interests of deterrence and rehabilitation. This court should substantially narrow or eliminate the foregoing conditions to comply with the First Amendment of the Constitution, Article 2, Section 6 of the Arizona Constitution, as well as Rule 3.6 of the Arizona Rules of Professional Conduct related to trial publicity. How many of you guys read this last night? What's going on, Utah Defender? The court must carefully review conditions of supervised release affecting fundamental rights. United States v. Wolfchild. Courts have emphasized the importance of avoiding overbroad restrictions on speech that is protected by the First Amendment. United States v. Gernkel. Condition of release must involve no greater deprivation of liberty than reasonably necessary. The United States v. Soltero. Condition limiting association with any known member of any disruptive group was overbroad for abridging the right to strike or protest. So, I mean, they're talking about specific any known member of any disruptive group. Well, I mean, I'm not a member of any group. You know what I mean? I'm certainly not any disruptive group. And even that's overbroad. Yeah, Walt, the Chase Allen story is one. What up, Sly? Is one to never be forgotten. It's a clear case of murder, in my opinion. I don't want to get off on Chase Allen, but there's another display of disgusting government parasites that slayed a kid for existing, for trying to express his rights. Oh, it's so gross. Release conditions restricting speech are classic examples of prior restraints because they actually forbid speech activities before they occur. We'll try that whole sentence again. Release conditions restricting speech are classic examples of prior restraint because they actually forbid speech activities before they occur. Alexander v. United States. Ordinarily, such prohibitions would be considered unconstitutional restraints upon publication. Near v. Minnesota. In the supervised release context, however, conditions restricting speech may be valid Prior restraints only when narrowly tailored and reasonably related to deterrence and rehabilitation. United States versus New Triumph, Inc. This court must ensure that conditions do not impose an overly broad prior restraint on speech lacking plausible justification. Well, there's no plausible justification here other than for the people in Tucson or Pima to hide their criminal activity from the public. I don't think that's a plausible justification to I don't know, but to do prior restraint or impose a broad prior restraint on speech. This court must closely scrutinize those conditions and their application to prevent them from casting a pall of fear and timidity over those under supervision. I can see that. I can see the pall of fear and timidity over Mr. Myers. And frankly, I think that everybody that's being objective, I'm actually being serious. Because we all know how Lane would behave otherwise. There would not be a pall of fear and timidity around the live streams that he does or the videos that he does. But there is, because there's this looming threat of prison for accidentally saying Shannon or saying Matt Walker's a corrupt prosecutor, or saying that these people are public officials that need to be scrutinized by the public. We're the public. We're here to scrutinize, and a pall of fear and timidity has been cast over Mr. Myers because he certainly can't criticize Mr. Walker. He certainly can't criticize Shannon Walker and her 33 lies. You know what I mean? Preventing them from casting a pall of fear and timidity over those under supervision who would give voice to public criticism. And that's all he does. He gives voice to public criticism. He says, look at these corrupt public officials. Let's scrutinize them. I love it. You know what I mean? Like, what kind of Americans are we supposed to be? I mean, really, what kind of Americans are we supposed to be? Are we supposed to be the fearful and timid Americans that we see so much of? The tattling, fearful Americans that everything is cause for government involvement. You know, everything is a cause for some measure of control. I'm sick of it. And I respect Mr. Myers for the way he goes about things. New York Times Company v. Sullivan. This issue concerns the public just as it does Myers because the freedom of speech serves significant societal interests wholly apart from the speaker's interest in self-expression and protects the public's interest in receiving information. Pat Gas and Electric Co. v. Pub Utility Commission, quotation marks and citation omitted. Under the First Amendment, speech concerning public affairs is more than self-expression. It is the essence of self-government. Garrison v. Louisiana. Therefore, speech critical of government is subject to the highest degree of First Amendment protection. Wolfson versus Concannon. That protection extends to criticism of those responsible for government operation, lest the criticism of government itself be penalized. Rosenblatt v. Baer. Criticism of police officers and other public officials is often pointed and harsh, but the sort of robust political debate encouraged by the First Amendment is bound to produce speech that is critical of those who hold public office, which will not always be reasonable or moderate. Hustler Magazine versus Falwell. The First Amendment reflects our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. New York Times. Therefore, in public debate, we must tolerate insulting and even outrageous speech in order to provide adequate breathing space to the freedoms protected by the First Amendment. Snyder v. Phelps. Whether the sentencing court may have intended, this court must review the language of the condition as it is written and cannot assume that it will be interpreted contrary to its plain language. United States v. Aquino. These conditions chill protected speech by requiring Myers to guess at its contours. Gentile v. State Bar of Nevada. An individual on supervised release could not be faulted for staying far away from speech that might encroach on vague conditions, is what we're talking about here. I mean, come on. Aquino, individuals should not be forced to guess whether an overzealous probation officer will attempt to revoke their supervised release, regardless of assurances the government might make about the vague condition. We cannot assume that, in its subsequent enforcement, ambiguities will be resolved in favor of adequate protection of First Amendment rights. Doe. The First Amendment protects against the government. It does not leave us at the mercy of the noblesse, I don't know how to say that, noblesse oblige? I don't know. I can't read. And this court should not uphold an unconstitutional condition merely because the government promised to use it responsibly. U.S. v. Stevens. Morning, Brett. Yeah, constructive criticism. Yeah, that's harassment. That is particularly true where, as here, conditions of probation are based on vague and undefined term. The sentencing court failed to define what mention or about Shannon Walker or Matt Walker might be, nor is there any clear definition on that term for Myers to adhere to. All right, bro, stop. Sorry, I got dogs. The sentencing court's reliance on such a vague term should itself void that condition. See Dambrot versus Central Michigan University. University code prohibiting negative or offensive speech was void for vagueness. California Teachers Association versus State Board of Education. When the First Amendment freedoms are at stake, courts apply the vagueness analysis more strictly. If the condition against speaking about or mentioning a government employee, public court cases, court documents, performances as a government employee is upheld, performance as a government employee is upheld, it could easily stifle valuable speech from activists and others under supervision. For instance, in a letter from Birmingham jail, Dr. Martin Luther King remarked that we are sadly mistaken if we feel the election of Albert Broutwell as mayor will bring the millennium to Birmingham. While Mr. Boutwell is a much more gentle person than Mr. Connor, they are both segregationists, dedicated to maintenance of the status quo. Had Dr. King been subject to the same conditions as Mr. Myers, he might have been resentenced for some of his most popular writing. Worse still, he might never have published at all. Yeah, well, he's got basically a gag order on him, kind of like you do, where the judge can just do. They think they can just do whatever they want and run roughshod over the people, and that we're just going to timidly sit by and take it on the chin. Individuals on probation, parole, or supervised release are uniquely qualified to critically evaluate one's encounter with the criminal justice system, document scandal and corruption in government and business, describe the conditions of prison life, or provide an inside look at the criminal world. Keenan versus Superior Court. Because they are likely to have informed and definite opinions on those subjects and others, it is essential that they be able to speak out freely on such questions without fear of revocation proceedings. Pickering versus Board of Education. Yet these conditions as written, if imposed on others in the future, could deter contributions to public dialogue on issues of importance. Thus, the conditions of probation prohibiting statements or videos that mention or speak about Shannon or Matt Walker or cause others to harass or contact government employees violates the First Amendment on its face. The court should strike that condition entirely. The sentencing court's conditions are void on their face because they discriminate based on viewpoint by prohibiting criticism, but not praise, of public officials and others. The First Amendment prohibits, above all else, discrimination based on the viewpoint of speech, essentially in the political context. When the government targets not subject matter, but particular views taken by speakers on a subject, the violation of the First Amendment is all the more blatant. Rosenberg v. Rector and Visitors, University of Virginia. Also see Reed v. Town of Gilbert. Even in the limited circumstances where the government may restrict the content of speech, it may not discriminate based on viewpoint. Cornelius versus the NAACP. The conditions as imposed preventing Mr. Myers from criticizing public officials, but do not prohibit him from praising them. Accordingly, the sentencing court's order impermissibly regulates speech on the basis of the speaker's viewpoint. Chaker v. Krogan. The sentencing court's ability to impose conditions of supervision does not extend to viewpoint-based conditions, especially when they may encroach on political speech. See Best v. Nurse. That one. Parole officer violated the First Amendment if he acted against parolee because he disapproved of literature he was distributing. We need to get some handbills and start dispersing handbills to the public outside of Tucson City Court about Matt Walker, the corrupt city prosecutor. I wonder if handbills are allowed. I wonder if he's allowed to disperse handbills. Sobel versus Reed. Denying others the hearing of parolee's views on prison conditions violates the First Amendment. Highland v. Procuner. State may not prohibit parolees from addressing lawful public assemblies because of the expected content of speech. People v. Warren. Court could not require a contribution that would advance one side of the gun control controversy. The same is not true here, where the conditions restrict pure speech based on viewpoint, not just conduct or limited association rights. Even in the context of probation, the government has no legitimate interest in imposing a viewpoint-based restriction on pure political speech. As a result, the conditions as written are unconstitutional on their face. The sentencing court could not evade the First Amendment's restrictions by crudely cobbling together elements of defamation and harassment. Regardless of labels and legal theories, the First Amendment prohibits any punishment for speech criticizing public officials unless the strict requirements for proving defamation are met. See Hustler magazine. The government thus cannot avoid the obstacles involved in a defamation claim involving a public official by simply relabeling it as a claim for intentional infliction of emotional distress. Don't be a dirty cunt, and we won't make videos about you being a lying dirty cunt. I don't know, seems like common sense to me. By simply relabeling it as a claim for intentional infliction of emotional distress. Like, Shannon, specifically, like, we wouldn't even talk about you. You know what I mean? Like, had she not gone into court and lied, we certainly wouldn't be talking about her. You know what I mean? Like, the gas is just so ridiculous here. You work for the University of Arizona, you get scrutiny, you dirty, nasty cunt. It thus exemplifies the purpose behind the Bill of Rights, and of the First Amendment in particular, to protect unpopular individuals from retaliation and their ideas from suppression at the hand of an intolerant society. Wow, if that isn't a definition of exactly what's going on here, I don't know what is. Lane Myers. That's the story. I guess I can't comment on my own shit. Let's see if I can do it over here. Boo. Alright, I can't do it, so. Let's see if we can do this, though. Yep. That'll do it. Oh, it's too long. Boo. Alright, whatever. That principle is especially important for persons convicted of crimes who may have important messages to convey but fear identifying their past mistakes. As with other forms of expression, the ability to speak freely on the internet promotes the robust exchange of ideas and allows individuals to express themselves freely without fear of economic or official retaliation or concern about social ostracism in anonymous online speakers. Therefore, the condition against any mention or statement about Shannon or Matt Walker must be stricken or narrowly to remove improper restrictions on public speech. Because we get to talk about your corruption, Matt. We get to talk about your lies, Shannon. Where they're never going to be forgotten. You made a huge, stupid mistake, and we're here to remind you about it forever. Forever. Until there's an about face. Until you say, listen, I was wrong. I shouldn't have done this. I apologize. Until that's done. Warren, are you that dumb? Not all speech is protected under the First Amendment, Warren. Thanks, Warren. Thanks for coming into the chat with the most common sense shit ever. Warren. He cares about your rights, everybody. Warren, are you Canadian or are you American? I can't remember. You live over by me, don't you? Why don't you ever answer the phone when I call? Warren. Warren. Why don't you ever answer the phone when I call, Warren? I just want to have a conversation. Have a little talk. The district court imposed overbroad conditions against the posting of any information about Matt or Shannon Walker. That's Cajun Randy. That is true. You can do that. You can absolutely do that. But Warren might scream into the chat and say, Oh, but that's not protected. Thank you, Warren. For everybody that might not be a retard, I guess some things need to be said. Some things need to be said. I don't believe that we should be threatening people. I don't believe that we should be dragging people out and tarring and feathering them in the public square. Although, I'm pretty sure we used to do that to public officials. I'm advocating for words, for communication. I'm advocating for logic, for a civilized conversation to prevail. But that's my side. We've got people like Warren who say I'm some malcontent that's trying to get people hurt on the internet because I'm pointing out their flaws as a public servant. Shannon Walker lies 33 times to a judge, and I'm the bad guy for saying, Shannon, you shouldn't lie to the judge. And hey world, Shannon's lying. We shouldn't be allowed to do that. We should allow Shannon to run roughshod and lie however much she wants to whoever she wants, because Warren thinks something. Who knows what Warren thinks, but Warren is a troll. He's a well-known troll on this channel, Walt. We love Warren around here because he's so backwards in his logic that he can't even defend his own positions. We're waiting if you can, Warren. The conditions imposed on Mr. Myers against posting or revealing any information that is about or mentions Matt or Shannon Walker or engage in activities that would reasonably expect to cause others to harass or contact the victim or her family on the internet are overbroad because they improperly chill protected speech on matters of public concern. Although conditions might be narrowed to comply with the First Amendment, as written, they reach far beyond any legitimate interest in deterrence and rehabilitation. What had nothing to do with Shannon's case? When I said all speech is not protected, had nothing to do with Shannon's case. Okay, Warren, why do you have to come in here and say retarded shit? We all know that all speech isn't protected. When did I say all speech was protected? Did I start my stream by saying, listen up, everybody, you get to say whatever the fuck you want without any consequence? Without any consequence. You can say whatever you want without consequence. Did I say that, Warren? Why do you have to come in here and act like a retard? Huh? Why? We know that all speech isn't protected, but I'm missing the part where Lane Myers had where there were true threats. Did Mr. Myers threaten anybody? Did he tell anybody to threaten anybody? Did he tell anybody to be violent with anybody? No, he didn't. No. None of those things happened. None. Zero. Never happened. In the history of time, never. But we've got morons like you, Warren, that come on and say, oh, well, all speech isn't protected. Well, okay. Can you please point out the speech that any of us are speaking that isn't protected? Because right now, you just sound like a fucking retard. Oh, jeez. Although conditions might be narrowly tailored to comply with the First Amendment as written, they reach far beyond any legitimate interests in deterrence and rehabilitation. Warren needs to read that sentence several times. Wow, you're retarded. So right now, Warren, we're reading a motion to modify his conditions of probation. You don't know why Lane pled guilty? Are you that Are you that dense? Because I know that you were in every single one of my live streams hate watching. So are you really going to pretend like you don't know why he pled guilty? Is that what we're going to do, Warren? Is that what we're doing today, Warren? Are we going to pretend that you don't know exactly what's going on? All of the videos, I believe all the videos are on my channel. Please link to the threats. Please link to anytime ever that Lane said something violent or said something that would induce somebody to be violent. Tell me how the person that literally in the channel name, we've got nonviolent. Lane Meyer's channel for nonviolent social change. Okay, Warren. Okay. Let's just parse this. Okay, so it's Lane Meyer's channel. Okay, so there it is. It's his channel for sure. Okay, now what is his channel about? What's it for? What's it stand for? What is the essence of his channel? And the essence of his channel is for non-violent social change. Okay, so has Mr. Myers ever advocated for violence, Warren? You inbred hillbilly? No, of course he didn't. But here you are. Here you are. Come on in, Warren. Come on in. Maybe Lane didn't threaten her, but his actions on the internet did cause her and her family to get death threats. So what? What does that even mean? Maybe Lane didn't threaten her, but his actions on the internet did cause her and her family to get death threats. Okay, we'll ride with that retarded logic for a minute. Okay, so right now I'm making a video about this motion, and the motion is going to go in front of Judge Griffin. Here, let me see here. Judge Griffin. Judge Griffin. All right. Judge Griffin. Bear with me, folks. I know that we're getting off topic here, but sometimes you just need to teach a lesson. And I understand that some people, even when they're given the lesson, they're too dense to understand. So here's what we're here to do, Warren. Let's minimize that. Let's get that up. And V. Okay. Alright, let's go back to Warren's stupid message. There it is. Let's go ahead and pin that guy and talk about it for a minute. Okay, so there's the contact information for the judge. And what I guess I want to understand, Warren, Lane didn't threaten her. Okay, so you're admitting that Lane didn't break the law? he didn't threaten her? Maybe Lane didn't threaten her. Okay, Lane didn't threaten her. That's a fact. But his actions on the internet did cause her and her family to get death threats. Did he tell anybody to threaten them with death? If somebody took the information that I just put in the chat, if somebody took that information and called the judge up or emailed the judge and threatened him, is that my fault? Did I encourage anybody to do that? You idiot. See, that's the thing about morons, is morons are so stupid that they can't even follow their own logic. Maybe he didn't, but his actions. See, I just can't. I can't circle your square, Warren, because it doesn't make any sense. Exactly. Lane exposed the lies, and they couldn't take it. All right, so I apologize, everybody, for getting off on that tangent, but it just, when people come in to the chat and they say stupid things like that, and a man went to jail, he was held, his freedom was stolen from him, and Warren doesn't care because he said, well, he was saying this stuff on the internet. Well, he wasn't lying. Everything that he was saying on the internet was true. The public officials were doing corrupt things against their oath, but we should just explain to me why Lane in the first place. I don't know exactly. Oh my God, bro. This guy. Why do we have to do this every time, guys? Tell me why. Tell me why we gotta do it every single time. We're gonna parse it, Warren. We're gonna parse it for you because I shouldn't give you the attention, but I'm going to. Bear with me for a second, everybody. Okay, here. Let's go there. Oh, I wish these were neatly here. Here it is. Okay. Is that it? Warren wants to know. Okay, let's. I apologize, everybody, but sometimes we need to make an example, and it's worth it. So okay, so explain to me why Lane contacted Shannon in the first place. I know exactly why he did. To intimidate her husband. Okay, well that's quite a bold claim. He knows exactly why he did it, to intimidate her husband. Did he need to intimidate her husband at all? Wasn't he spanking the shit out of him in open court? I'm wondering. But here we are. We're going to listen cuz this is apparently this is Lane intimidating Matt, I guess. All right, let's get to the bottom of it.
This is a public service.
Director of Special Projects. You have reached Shannon Walker, Director of Special Projects at the James C. Rogers College of Law. Please leave a message and I'll call you back.
520-771-2021. I see you're Director of Special Projects. Well, I'd like to ask if you could approve a special project where you help me end your husband's career for being a crooked-ass cop, prosecutor, wannabe, whatever he is, hiding these cops from prosecution. I figured that you, okay, maybe Stacy could help me. Maybe I should talk to you or Stacy or maybe one of these. Because, you know, my wife also is an alumni of the College of Law and is actually has taught there. So like we got two sides that are about to come crashing together here. So you can help me teach your husband how to follow the law, or I'm gonna take his career.
Okay, Warren, I'm waiting. Shannon in her message said that she's the director of special projects. So we just want to get the facts out here because Warren's going to try to build this narrative that only exists in his mind. These are the facts, Warren. She is the director of special projects, and Lane specifically asked if she could help him work on a special project. What? Where you at, bro?
Maybe Stacy could help me. Maybe I should talk to you to approve a special project where. Well, I'd like to ask if you could approve a special project where you help me.
It's already been proven that the University of Arizona, Shannon's office, works with the Tucson City Courts, works with Matt's office on special projects. So it's okay that the wife of the prosecutor works on some special projects with the Tucson City prosecutor, but you can't talk about it. You can't bring it up. You can't do any of that. No.
And your husband's career for being a crooked-ass cop.
And some help ending the career of a public official that's doing corrupt things. Is that a threat? Is that a threat of violence? What is this retard going on about? All right, so that just got us to understand that Warren is just, he's beyond help. So did she have the power even to get her husband fired? What? What are you babbling about, bro? Oh boy. Do not call family members of a prosecutor. Well, unfortunately, the family member of Well, then what are you going on about? You're saying that somebody else threatened her, but he never asked people to threaten her. You see videos on YouTube. If you see a news story and you get upset, and if somebody sees a news story, they get upset and they threaten, it's the news company's fault for releasing the story. Your logic, you can't even twist it into something that makes sense, bro. You're so warped. It's gross. And then your little buddy, definitely not pants, doesn't understand things either. She works for the University of Arizona. She's a public official too. It doesn't matter, bro. She's a public official too. If she worked for Walmart, you're right. He couldn't contact her. He wouldn't be able to lawfully contact her. But he didn't say, "I want help with my case." He didn't say anything like that. The thing is that the law is nuanced, right? We'll see. We'll see if I'm wrong. I don't believe I'm wrong. And it doesn't even matter. Because Warren couldn't get himself out of that circular logic hole because he has no logic. Who knows? She had did he have the power to help her get her husband fired? It wasn't about getting her husband fired. It was about a special project. It was about doing a special project. Whatever special projects between her office and the Tucson city courts, they were working together, right? There was still a special project, whether or not it succeeded in its efforts or not. The special project still existed. So the special project that he was looking for was one to get a corrupt prosecutor fired. I'm all about getting corrupt prosecutors fired and corrupt public servants that work for the University of Arizona. I'm all about getting them fired too. So Warren stacked up another L. Sorry, bud. That's all the attention I'll be giving to him for the day. The mere invocation of privacy without more does not defeat the First Amendment rights. The First Amendment allows liability for an invasion of privacy only if the matter publicized is of a kind which is not of legitimate concern to the public. Oh, kind of goes right to the heart of it. The First Amendment allows liability for an invasion of privacy only if the matter publicized is of a kind which is not of legitimate concern to the public. Well, is public corruption of legitimate concern to the public? Yeah, I'd say so. Virgil v. Time Inc. In addition, the government may not generally punish the publication of truthful information. That's another thing. So did Mr. Myers ever lie? Yeah, keep trying, Warren. Maybe you'll get through. Maybe someday common sense will get through to these people. Keep hate watching, you moron. Can you imagine watching something that has absolutely no effect on your life because you hate it, because you think you're going to get through? You think you're going to get through to me, bro? Are you insane? You think you're going to get through to me? Get through to me? Get through to me? The government may not generally punish the publication of truthful information. Truthful information, lawfully obtained. That's what we're talking about here. I don't think so. I think I'm going to hold the government accountable, and just because you work for the government or because you like oppression doesn't mean I'm ever going to change, bro. I'm never going to change. It's never going to happen. Never going to change. The condition imposed on Mr. Myers against revealing public information must therefore be narrowed to allow disclosure of information that is of legitimate public concern and obtained by Myers through lawful means. See Barnicki versus Vopper. Similarly, the condition against do not engage in activities that would be reasonably expected to cause others to... This is the one that Warren can't seem to wrap his head around. Similarly, the condition against do not engage in activities that would be reasonably expected to cause others to harass or contact the victim or her family must be narrowed or eliminated to prevent the infringement of protected speech unrelated to deterrence and rehabilitation. As courts have confirmed, constitutional protection is afforded some false statements because an erroneous statement is inevitable in free debate, and it must be protected if freedoms of expression are to have the breathing space that they need to survive. Not in Warren's mind, though. Warren thinks that you should just shut the fuck up because he's right, you're wrong, no evidence needs to come into it. He just says so that's the way it is. Although the government may punish certain false claims, I'm still waiting for the false claim on this one, but okay. Made to affect fraud or secure monies or other valuable considerations. False speech is not presumptively unprotected by the First Amendment. United States v. Alvarez. Yeah, so even if he was lying, which he's not, it's still protected. She could sue him for defamation. Well, I wonder why she hasn't. He's called her a liar up and down. I wonder why she hasn't taken him into court. Huh, it's weird. Mr. Myers wishes to post on his personal blog statements regarding the professional history and performance of public officials that were derived from personal experience and other internet sources, and for that he is being improperly punished. This is the statement, Warren. That's the statement that you need to read and that you need to get through your head, that he's allowed to do these things. Like, she doesn't have to watch. He's not asking, just because I'm not asking anybody to reach out to Shannon. I'm not asking anybody to reach out to Matt. But if somebody reaches out to Shannon or Matt, it's my fault? Because I'm talking about this case? Is that what I'm to understand? That's tough, man. The conditions of supervision that the sentencing court issued against Myers and many of the conditions subsequently imposed, such as prohibiting and posting of any mention of Myers' court cases. I bet there's a legal reason behind that. Removing his fundraiser because others mentioned Shannon or Matt Walker. Removing videos related to Matt Walker's prosecution of Myers. Removing recordings of his own court hearings. What was the reason for that, Warren? Is that harassment too? Putting up his own court hearings? That's harassment too? Removing comments on government social media about or mentioning Shannon or Matt Walker, restricting Myers' ability to speak with news outlets about his case, restricting his ability to attend public meetings and speak about his case, and similar impositions do not comport with the First Amendment. The foregoing conditions imposed by the sentencing court should be stricken or substantially narrowed. The sentencing court imposed unconstitutional restrictions on Myers' association rights. Myers next argues that the restriction that ordering Myers do not associate with or communicate with directly or indirectly Josh Gray or Mark Kelly is also unconstitutional because there is no legal or factual basis for this. There is no material facts in this case that support this restriction. This is completely arbitrary. Why, of all people on earth, were these two chosen? This case differs from those where courts upheld narrow restrictions on certain forms of political conduct or association closely related to the circumstances of the underlying offense. See U.S. v. Schiff. Restricting a person convicted of attempting tax evasion from associating with people who encourage tax evasion or participating in meetings advocating for such unlawful activity, Malone v. U.S. Defendant convicted of unlawfully exporting firearms prohibited from associating with certain groups because the crime stemmed from high emotional involvement with Irish Republic sympathizers. These courts upheld only closely tailored conditions against particular conduct or association directly connected to the conviction, not broad restrictions on pure speech or association, political or otherwise. As a result, the defendants remain free to legally associate with anyone, voice their opinions, and criticize public officials. Therefore, this condition must be eliminated. Proposed conditions. Myers recognizes this court's necessary balancing act and does not feel the need to get hung up on being able to post Shannon Walker's personal contact information or encourage others to contact her, so this argument is not attempting to get into that area of complexity. Myers concedes for judicial efficiency that he is not asking to post Shannon Walker's private information or encourage others to contact her because that is not his end goal. Listen carefully, Warren. For those reasons, Myers is proposing the following, or close to, conditions. This will allow the court to protect Shannon Walker and still give Myers his rights back. This court has no legal standing to limit communications about Matt Walker, the city of Tucson prosecutor, solely because he is married to Shannon. Matt Walker is a government parasite and is subject to official scrutiny as such. There is no legal precedent or narrowly defined government interest to restrict public speech about or involving a government official. Proposed conditions language. Do not contact Shannon Walker, her kids, go to her home or place of employment. Where does she work? Where does she work, guys? Do not encourage others to contact Shannon Walker, her kids, go to her home or place of employment. But where does she work? I'm just curious. Does she work at Walmart? Allow probation full access to YouTube and social media to determine whether you are abiding by the conditions. Whew. Only remove videos from YouTube and social media that include personal identifying information about Shannon Walker, Matt Walker, or their kids. This does not apply to public records, publicly available information, government contact information of Matt Walker, or information contained on government websites. Do not post personal identifying information, including workplace information about Shannon Walker and her 2 kids on YouTube or social media. This does not apply to public records, publicly available information, government contact information of Matt Walker, or information contained on government websites. Myers is allowed to speak about, mention, and criticize Shannon Walker in matters of public concern, court cases, public records, and legal analysis. Myers is allowed to speak about, mention, and criticize Matt Walker in matters of public concern, court cases, public records, and legal analysis. Myers is not responsible. Warren, listen up, Warren. Warren, please, and definitely not pants. Listen to this because you guys seem to be super retarded. Myers is not responsible for public comments or commentary that others make that include Shannon or Matt Walker on his social media or online postings. Do not send to or tag Shannon in any social media posts, emails, or other electronic communications. Oh my God, bro. Here, we're gonna take your rights away. Shut up. Conclusion. Myers asks this court to modify the original special conditions of probation to be consistent with the established case law and statutes, due process, and statutory limitations as required. Myers asks this court to find that balancing point of protecting Shannon Walker without overbroad and vague restrictions on Myers' First Amendment protected activity. Myers must be granted the ability to speak about his own cases and matters of public interest, free from retaliation and prosecution for his views and opinions. This court must establish a clear boundary between encouraging others to contact and merely speaking about Shannon Walker. Yeah, do not contact Shannon. Okay, guys? As long as Myers doesn't post her contact information or encourage others to contact, he cannot be held responsible for what others say or do in regards to Shannon Walker. Merely speaking about or mentioning Shannon Walker in social media posts is not something that the sentencing court can prohibit. Social media is no different than going to the park and standing on a park bench and speaking to an audience. Therefore, must be analyzed as such. There is no gag order in this case, and as the case law in this motion shows, distributing public information to third parties is constitutionally protected. Therefore, there is not a narrowly defined compelling governmental interest in prohibiting Myers from distributing public information about Shannon and Matt Walker to third parties as a special condition of his probation. Furthermore, the condition prohibiting any communication or association with Mark Kelly and Josh Gray is not supported by any legal or factual basis and must be eliminated. This is yesterday by Lane Myers, the pro se idiot. All right, guys. Well, now it's in the Dabbler's hands. The Dabbler's going to have to dabble. The Dabbler is going to have to dabble. We have any closeout questions or anything? Let's see if we can do this. Since my music was all messed up at the beginning, is that what I'm hearing? Yeah, don't call, guys. Don't call. Don't call. Don't do it.
Why can't we just be friends? Why we always gotta fight? Why we always gotta focus on that dark instead of following the light? Why can't we just be cool? Cause at the end of the night, we're always gonna have our differences.
Thank you, everybody.
That's alright. That's alright. Trying to find a light, that sunny side of life. Trying to find a vibe in these life and times, but all I find's a fight. See now everybody got their fuse lit. It's a world of dynamite. But when you scrapping over that whole pie, there's no time to find a slice. I took my time to find a bite. That food tastes good. They'll take a seat at my table, just like I knew they would. No bickering up in my kitchen, so just say that shit. Cause we just here to give thanks, get the bread and break that shit. So listen, take a minute, please. Like when take a hit and breathe. Come to terms within yourself that it's okay to disagree. Y'all know people gon' be people, they gon' label what they see. But I'll break your label maker if you hanging out with me. Just be cool, just be civil, just relax, just a little. You could be on the left or the right, or come chill with me in the middle. Either way, make amends, shake a hand, make a friend. Cause who else gon' have your back up in the end? Why can't we just be friends? Why we always gotta fight? Why we always gotta focus on that dark instead of following the light? Why can't we just be cool? Cause at the end of the night, we're always gonna have our differences, but that's alright. That's alright. We all don't get along, some shit, I'ma be real, we all are doomed. Read the room, if we gon' stay divided, I can only assume that this world will only get darker as we go farther into this rabbit hole. Round and round on this merry-go with no common ground to just grab a hold with this polarization all over the nation. Communication at an all-time low as a population. No cooperation, misinformation all over your station.
Yeah, that's Webby.
Want conversation, cause they know that right there's the foundation of love. And once we realize that, the whole game is done. That power that they hold over us, with unity we take it from. Don't got a friend, start making some, cause all we got is each other. As the rich get richer and the bad guys win, gotta put our faith in a brother, or in a sister, or in a them a they. Cause honestly, yo, at the end of the day, we on the same team. I'm just giving the premise to play, cause life is crazy enough. Let's find a better way. Go spread some love, go make a friend and say, why can't we just be friends? Why we always gotta fight? Why we always gotta focus on that dark instead of following the light? Why can't we just be cool? Cause at the end of the night, we're always gonna have our differences, but that's alright. That's alright.
This is a public service.
This is a public service.
We're out here today to ensure our natural rights are respected by those who sworn in to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and like, share, and subscribe so this message can reach as many people as possible.
I can see your comment, X.
To peacefully seek redress to any and all of your grievances. This is